Good afternoon, everyone. All right, we're going to go ahead and get started, so if everybody could take a seat. I know lots of you probably have questions for the panelists, which is why we want to go ahead and get started on time. My name is Sarah Williamson. I'm a 2L here at Duke Law School. Thank you especially to those of you who've come from the outside community and from other Duke schools. Welcome to the law school here today. What I'm going to do is give a brief introduction to our panelists, and then I'll kick it right off with some questions and we'll get the discussion going. So first, here on my left is Professor Chris Schroeder. He's the Charles Murphy Professor of Law and Public Policy here at Duke Law School and co-director of the program in public law. Relevant to his participation on the panel today, he has previously served as Assistant Attorney General in the DOJ Office of Legal Counsel, and he's also served as the Chief Counsel to the Senate Judiciary Committee. Then next to him, we have Professor David Gray. He's joining us here. Special welcome from the University of Maryland Law School, where he's a professor of law, and he's a Fourth Amendment scholar. He has an upcoming book entitled The Fourth Amendment in the Age of Surveillance, and he's also co-editor of the upcoming Cambridge Handbook on Surveillance Law. And seated next to him is David Hoffman. He is a Duke Law alum, and in the fall semester, he co-teaches with Professor Schroeder a course on data privacy and government surveillance. And his day job, though, is Director of Security Policy and Global Privacy Officer at Intel Corporation. And then last but not least, we have Professor Stuart Benjamin. He is the Douglas Maggs Professor of Law here at Duke Law School and Associate Dean for Research. He specializes in the First Amendment, telecommunications, and administrative law. And prior to his tenure here at Duke, he was the first distinguished scholar in residence at the FCC. And he's also had a brief stint in the Office of Legal Counsel at DOJ as well. So with that, we'll go ahead and kick it off. I'm going to give a brief background of some of the cases here that we're talking about, because the point of this panel is to really go back to the legal arguments that were in this case, rather than everything that we've all been seeing in the news lately, which has gotten divorced from some of the legal arguments of the parties. So we first want to get back to those legal arguments. And so first we're going to be addressing the Apple suit, which you're, of course, probably all aware of. In the past 2 years, Apple has received at least 11 public orders issued under the All Writs Act of 1789. Most of those have been to compel the company to use existing technologies and capabilities to extract data on locked phones. However, this February, the case at issue here, Apple was issued an order to create and electronically sign a new software that would enable the FBI to unlock a phone, work-issued phone, an iPhone 5C, which was recovered from the San Bernardino shooter, Syed Farouk. The FBI was able to recover the information that was stored in iCloud backups on that phone with the assistance of the city of San Bernardino, who was the employer and who issued the phone. And as we are all now well aware, an unknown third-party vendor, originally suspected to be Israeli-based firm Celebrite, but today released that it might actually be a group of unaffiliated hackers who assisted the FBI, and so that enabled the FBI to actually gain access to the data that was stored on the phone without needing to compel Apple to do it, and so therefore it dropped the case. So what I'm going to ask our panelists is, assuming that we were in an alternative world where this case actually went towards litigation, let's discuss what the best arguments for each of the parties would be. And first we're going to go with Apple, and Professor Hoffman and Professor Benjamin are going to address the best Apple's best arguments for us.
You want to go first? Do you want me to go first?
You should go first, since we probably have a dimmer view of these arguments than you.
And I'm sort of forced, since I wrote some of the arguments in the amicus brief that Intel filed with the help of another Duke Law alumnus, Dan Katz at Williams & Connolly. I think first you have to take a look at the All Writs Act, and I think that the arguments you can break out either from the language itself of the act or the three-factor test that the case law that has interpreted the act has created. So the act, the pertinent language in the act, as it was amended in 1948 and 1949, non-substantively, just slightly, is the Supreme Court and all courts established by act of Congress may issue all writs necessary or appropriate in aid of their respective jurisdictions and agreeable to the usages and principles of law. It's that language at the end, agreeable to the usages and principles of law, which has come to stand to say that it is a gap-filling authority for the courts to be able to enforce its jurisdiction in an area where Congress has not clearly spoken on the matter. So I think the first argument that Apple makes, we made in our amicus brief, a lot of companies have made, is Congress has actually spoken on this subject. The Communications Assistance with Law Enforcement Act, when it was passed by Congress, provides that telecommunications companies need to provide the ability to be able to decrypt communications when they are being transmitted over a traditional telecommunications network. When that statute was being drafted, on the floor there was discussion and in hearings about whether that statute should be extended in two different ways. One extension of that statute would be to extend it beyond the telecommunications carrier and extend it to other types of communication service providers. That was never done. The second extension would be, rather than just creating a situation where the service provider would have the keys to be able to decrypt content and then would have to decrypt that content, should the provider have to do other activities if they do not have the keys. The act was also not extended in that direction. So the argument is then, by not incorporating those authorities into CALEA, Congress intentionally decided not to provide the authority to the government to do the types of things that the FBI was asking Apple in this particular case. So that's the main argument that we made in our amicus brief, and I think it's the main argument that Magistrate Orenstein has decided the decision in New York based on. There are other arguments that Apple has particularly made, and that's based on the three-factor test that was predominantly described in a case called United States versus New York Telephone, describing the All Writs Act. The three-factor test for determining whether something would satisfy the All Writs Act would be, number one, the closeness of the relationship between the person or entity to whom the proposed writ is directed and the matter over which the court has jurisdiction. Number two, the reasonableness of the burden to be imposed on the writ subject. And number three, the necessity of the requested writ to aid the court's jurisdiction. There are arguments under each one of those provisions that can be made. Under the first, Apple has made arguments, some of the other amici brief have made arguments that going back to the manufacturer of the phone instead of just a service provider is not close enough in the relationship between the person who committed the crime and to whom a writ should particularly be directed, or the owner of the device. The second, the reasonableness of the burden. There's been a number of different arguments depending upon which case we're talking about, but if we're talking about the San Bernardino case, particularly they've been saying, look, in that case, it's not just providing the keys, but what the government wants is they wanted to force Apple to have software engineers engineer a new version of the operating system, which would then be loaded onto the phone to defeat a couple of key security features that made it difficult to do a brute force attack on the iPhone passcode. Apple's argument is that causing a company to have to develop new software to defeat its own security features is an unreasonable burden. They've also argued in some of the cases that it is an unreasonable burden upon a company like Apple to cause them to defeat their own security features, because it then means that they cannot market that phone as providing adequate security to their customers, and it's an unreasonable burden on their market strategy. The third would be the necessity of the requested writ to aid the court's jurisdiction. And I think this is the reason why you end up seeing the case being withdrawn. Apple's case argument always was, look, the U.S. government's supposed to have the best code breakers in the entire world. It can't be possible that you actually need us to break this. Go figure out how to break it yourself. It's not necessary for you to come to us. That ends up, in that particular case, being true.
So I have much less to say because I want to talk about just one part of the Apple argument that you all might be aware of. So in its submission to the court, Apple said computer code is speech. And because computer code is speech, this implicates the First Amendment because we are being required then, we are being compelled to engage in speech. Now, it is true that if there's an activity that involves your speech, you can't be compelled to do it without the government having satisfying strict scrutiny, which will be hard for the government to do. So if it's true that all computer code is speech, then Apple has a very strong argument that there is a constitutional problem then with them being forced to write speech. The reason I was emphasizing these words, computer code is speech, is I've written an article arguing that algorithmic speech is still speech. I'm calling it, algorithmic communications can still be speech, so that if you submit a query to Google and there's an algorithm that Google uses to respond to your query, that there's a substantive communication there because a human being has actually created a substantive communication to you. But that's quite different from arguing that all code is speech. Note that Apple wasn't even distinguishing source code versus machine code. It was treating this as all code. That actually goes back to a set of arguments that arose 15 years ago now when a particular computer programmer decided to write source code that would be readable by other humans as a way of defeating some encryption technologies. And he was really doing this as sort of a proof of concept. And so this was the best possible argument for some kinds of code being speech. This was code that you could read, and he was in fact doing it so you could read it. So you could understand what the arguments were as to how you yourself could then defeat the encryption. But if we're taking seriously the argument that all code is speech, including machine code, I'm hard-pressed to think then of what modern activities the First Amendment wouldn't apply to and therefore require strict scrutiny for. So I am a high-frequency trader. How do I trade? I trade, of course, through computer code. So I guess then any regulation of high-frequency trading now is subject to heightened scrutiny. I am engaged in wire fraud. How does that wire happen? It happens through code. I submit my grades to the students of mine who are in this class through code. And so I guess if I'm a law professor at a state university now, I have there's some claim about the state's involvement in regulating these kinds of communication. It is an argument with enormous breadth. It doesn't make it wrong. I guess I was simply struck by the breadth of Apple's argument. The reason they did that, I think, was, in effect, what the government's argument is, look, we're actually not asking you to engage in any communication that any other person can ever understand. And my own personal view is that speech requires that there be a communication that is sendable and receivable, that someone else could receive that communication and make sense of it, so that if I decide to start just sort of walking around saying beep, 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 you all will not have received a communication from that. Or if I start walking around saying, 11001100, again, that you all will not be able to make sense of it. There will not have been a communication that's been received. So I understand why Apple made the argument that it made. It wanted to say, even if it's just zeros and ones, even if it's just machine readable, that's still a communication. I just want to highlight to you all, we can now play the parlor game. So what activities in modern society, or certainly what economic activities, won't then be speech in our world in which so many things are done through various kinds of code, including, of course, everything you're doing through your smartphone. But let me stop there.
All right, so now we'll turn it over to Professor Schroeder and Gray to address the FBI's arguments.
Oh, great, thanks.
I mean, I'm happy to.
So I was on one of the other amicus briefs in the Apple case on the side of good and justice, and so I'm out of role here. But as I tell my students, argumentative empathy is one of the best skills a lawyer could have. So I'll do my best to make the best arguments for a losing side. So I think that the one of the important things to focus on with respect to the All Writs Act is whose power and authority is invested and expressed through the All Writs Act. And it's most definitely not the executive branch. It's an Article III writ that's issued in support of an Article III court's jurisdiction. And so a court could issue any number of orders to compel and need to issue a supportive writ in order to effectuate its jurisdiction. So what's really at stake in an All Writs Act case is whether a private party or another entity who has been hailed into court in a federal court can resist that court's order and be beyond any compulsive force by the court itself. And so it really, in some ways, in all ways, is a vehicle for effectuating the authority of the court. And one way to think about it is a sort of flexible contempt finding. And so what we have here is a lawful order issued by a United States district judge to search a phone. And the only way to effectuate that warrant, so says the government, is for Apple to assist it. And that falls, it seems to me, well within the ambit of the All Writs Act, because the alternative is that a lawful order of the court is never going to be effectuated. Its jurisdiction will be constrained by the contemptuous conduct of a spoiled corporation. And so if we are within the bounds of the All Writs Act, and the question is, can Apple participate in a thwarting of the lawful jurisdiction of an Article III court, then the real question then comes down to one of, are there other countervailing constitutional or legal concerns that make Apple not the right or the appropriate party to be subject to that writ? And I think that Professor Benjamin has done a wonderful job of tearing down the First Amendment argument already. One argument that wasn't made by Apple that I think is worth considering is a takings argument, to the extent that Apple has an invested property interest in a device that is impenetrable by any government or private entity. The encryption is that good. To the extent it's forced to violate that encryption and to get into the device, then it has sacrificed tremendous property value in that consumable. And so if Apple is forced to take value away from one of its most valued assets, then that certainly is a physical taking of value in this property. It's more valuable to me as a consumer if its encryption is impenetrable than not. The Fourth Amendment argument is taken care of fully, I think, by Riley, which just tells us that law enforcement has to get a warrant to get into a phone backed by probable cause. They had that warrant. The whole issue here is whether Apple can contemptuously thwart the vindication of that warrant. And so then we're down to those three factors of the All Writs Act. And these are, as with any multi-factor test, it's one that really comes down to the judgment of an individual court. But it is, I think, worth thinking about the policy implications of a generalized finding that no technology company can represent itself as solely an information service provider, not engaged in telecommunications services, and therefore not covered by CALEA, because not covered by CALEA, also immune from suit under the All Writs Act by an Article III court. That seems to me to be a backward argument in terms of the limiting force of CALEA. Surely these issues were discussed on the floor and in sessions when CALEA was being adopted, but were left off the table because there weren't really facts present at the time to make these kinds of issues relevant, which is to say that CALEA deliberately left an interstices in the law that can be filled by courts acting in the vindication of their jurisdiction. That they didn't act because they weren't faced with a problem that was ripe for legislative resolution doesn't mean that the issue is not something that can be resolved within the broad ambit of the jurisdictional authority of an Article III court, particularly in light of the fact that events have changed dramatically in the intervening 20 years or so. When CALEA was first debated and passed, we didn't have information service providers playing the critical and broad role that they play now in the communications and computing economy. It really was just telephone companies. And we didn't have Apple engaged in providing communication services through FaceTime or through iMessage. We didn't have devices that we carried on ourselves that stored information. All that information was stored, to the extent it was, with third parties, with our telephone companies, et cetera. So the issue just wasn't right for legislative resolution at the time that CALEA was debated and passed, but it certainly is now. And you might say, well, the legislature should step in and update CALEA, and you're absolutely right. But in the meantime, the question is whether companies like Apple can continue to act contemptuously to thwart the jurisdiction of Article III courts. And to me, the answer is clearly got to be no, particularly when you're talking about a company like Apple that markets itself as having a very intimate relationship with its customers. Those of us who are big fans of Apple products really think we're part of the family. They pull us into this closed universe of iOS and make us part of that close community, and in the process develop one-on-one relationships with us that are not mediated with other parties in the same way that that somebody who makes a telephone call has their communication mediated by the telephone company with the receiver. And that close relationship is one that Apple markets and develops, and so and it has to pay the price for that in recognizing that there's no intermediary here, and that intimacy that they've created creates a close relationship that it seems to me fills that first prong of the multi-factor test under New York Telephone. The burden here, they said it would take them a couple weeks to write the code, and that for a company like Apple, that is a small price to pay. You might try to bring in the takings argument sub rosa here by saying that the burden is not just in terms of the man hours, but the loss in product value. But the truth of the matter is that no iOS encryption is secure for longer than a few months or 6 months. Some hacker gets in, and that's why we're constantly pounded with updates, is because Apple is trying to constantly keep one step ahead, or rather not more than one step behind hackers. And so the burden here in terms of a short-term loss in the value of their product, certainly not so weighty enough to outweigh the jurisdictional interest of an Article III court. And at least at the time, Apple was not only in the best position to get into this phone, but the only one that people thought could get into this phone. That, of course, has become moot, which is lovely to find out. But when the next case comes up, if there isn't a third party available, then it's going to be Apple who's the only one who could do it, which certainly meets the requirement for necessity.
Well,
I almost bought it. Well, I almost bought it.
It was the word contemptuous that I think that's all.
Well, I'm not going to add very much to that excellent rendition, whether sincere or strategic. Except let me just point out one aspect of this case that I think has not received a whole lot of attention, which is whether what the government is asking Apple to do in this case actually falls within the description of asking it to decrypt the device when it doesn't currently hold the key, which is roughly the problem that CALEA, the Community Assistance for Law Enforcement Act, dealt with, and concluded that telecommunications providers don't have to assist law enforcement in decrypting a device if they don't hold the information necessary to do that. From a non-techie layman's perspective, this situation seems to me a step removed from asking Apple to decrypt the information on the phone. So let me put it in terms of a more physical world rather than virtual world example. Suppose you have the manufacturer of a safe, and the law enforcement officials have obtained a warrant from a neutral magistrate because they've convinced that neutral magistrate they have probable cause to believe that inside the safe is evidence relevant to a crime. They go to the safe, and it turns out the manufacturer of the safe has not only provided a combination lock that can be set by the user, which has been done in this case, but also 2 security enhancing measures, one of which would ignite the contents of the safe and burn everything in it if anybody tries to get in the safe without knowing the combination and makes 10 successive unsuccessful attempts. The second security device is one that will not permit the combination to be retried except after a lapsed period of time, and that period of time extends every time you make an unsuccessful attempt. So both of these devices make it very difficult for anybody to try to guess the combination. You either have to know the combination or find some other means into the safe. And let's suppose law enforcement doesn't believe that there is any other means inside the safe except by virtue of its efforts to figure out the combination. What it asks the safe manufacturer then to do is not give it the combination, which the manufacturer doesn't have, but to deactivate these 2 security enhancing measures. Is there a way, the manufacturer is asked, to cancel the 10 successive tries leads to the igniting of the contents of the safe and its unavailability to law enforcement, and to cancel the time delay feature of making unsuccessful attempts in the safe? And the manufacturer says, well, you know, we can't do that right now, but it looks like we could do it if we had a little time. And the law enforcement then says, take the time, I'm willing to wait. The manufacturer then goes ahead and provides those 2 deactivating devices, doesn't unlock the safe, doesn't provide the law enforcement with the combination lock, but then leaves it for the law enforcement to make its own efforts to unlock the safe. That, in a physical world analogy, is roughly what was going on here. The government was not asking for Apple to open up the safe. It was going to conduct its own electronic brute force attack on the passcode that had been put on the phone, but it couldn't do it because of the security enhancing measures that are roughly the equivalent of the 2 I've described that had been activated by the user prior to the law enforcement getting its hands on the phone. I'm not sure that what Apple is being asked to do falls within the contemplation of the Community Assistance of Law Enforcement Act as to what the legislatures were thinking about when they were saying manufacturers don't have to help decrypt an encrypted communication. So it's beyond the arguments that David has summarized, and which were unsuccessful in a case out of New York before Magistrate Judge Orenstein. I have a question as to whether Scalia actually speaks to this issue at all, which is important because Orenstein rested his conclusion that the All Writs Act did not grant the authority for the FBI to obtain the writ that it sought on the basis that Congress, when it enacted the Community Assistance with Law Enforcement Act, had spoken to this issue. Spoken by not enacting something, which is yet a further problem in Orenstein's argument, since he makes much of the fact that Congress debated but did not enact a provision. So he's resting a lot of his argument that granting a writ in this case would be not agreeable to the principles and usages of law on Congress's failure to act. And I think there are lots of problems in placing any weight on the substantive force of congressional failures to act, simply because there are so many reasons, short of there being a well-defined majority in opposition to the measure, as to why Congress doesn't enact a measure. So those are just the 2 additions I would give to my sense of the government's case in the Apple litigation.
Okay, so now that we've heard the arguments on both sides, obviously we did have a resolution here in the FBI's withdrawal of the suit. We know that this probably won't be the last time we hear those arguments in the near future, but we have started hearing about the vulnerabilities equities process, which was established by a White House memorandum in 2014, I think, and it's the process through which the government evaluates several factors to determine whether to disclose a vulnerability that it identifies in a software, hardware to the manufacturer. Just this past week, we've learned that Apple does not intend to sue the FBI to obtain disclosure of what the vulnerability was. However, it's still unclear as to whether the FBI is going to release this information. There's been indications that they're sort of going through this equities process. And so I want to ask the panelists, what do you think the outcome will be, of the FBI's deliberations here? Do you think they will eventually disclose the vulnerability to Apple?
It kind of comes down to, do you think the FBI is the bigger man? Or are they going to meet spite with spite? And I think this is one of those circumstances where we were talking about using this phrase a little bit before the session started, but General Michael Hayton, who is a sweetheart of a man, if you ever had the chance to meet him, was on Apple's side in this case, much to the chagrin of many of his securities colleagues. And his view was, well, look, encryption is part of the game, and these companies, our foreign enemies, our foreign allies, use encryption to try to keep us out, and we try to break encryption to get in, and it's game on. That's his phrase. It's game on. And so if it's game on, and that's sort of the way that Apple painted this, was we're not going to do it yourself, then I have a hard time seeing the government turning around and saying, okay, well, we'll be cooperative. Although if you look at survivability and tit-for-tat games, the right move mathematically is for the government to cooperate here rather than respond with another tit or tat.
Well, I think it's one where we may have a difference of opinion. I could easily see a situation where the government would say the right thing to do from a public policy perspective here is to disclose the vulnerability. A couple things about vulnerabilities that will add to this discussion, and one of the reasons why I believe that Apple will continue to contest these cases, these all writs Act interpretations are going to be incredibly important, is because in this particular case with this particular phone, we were talking about, as Professor Schroeder I think created a wonderful analogy to describe the creation of a new mechanism to be able to defeat security features. Well, with just about any piece of technology that's out there, the technology developer probably knows between 5 and 20 different vulnerabilities that they are working on at that particular time that could be used to access some information on the device. So one case that's hanging out there would be, would there be a situation where the government would come to Apple, let's say, and say, we know you must have vulnerabilities that you know of and you are working to cure. We'd like you to use one of those, or we would like you to disclose that vulnerability to us so that we can use that. It'd be an interesting case. I think different facts, all of these factors would play out in a different way. So the vulnerabilities exist within the technology community. The vulnerabilities also exist within the government. So that's happened for a long time. I described before that particularly the NSA has been described as the best code breakers in the world for over 60 years, since World War II. And so at any point in time, they have vulnerabilities. There are other agencies in the government that also have vulnerabilities. This became a big issue within the technology community, let's say over the course of the past 10 to 15 years, where people were saying, look, if you know that there are vulnerabilities with the devices that we make and we sell to the government, and we sell to the critical infrastructure of the country, please tell us how it's the right decision to keep those from us where we could repair them and actually make the country safer and a stronger nation. So in 2010, the Obama administration, this has now been released to a FOIA request by the Electronic Frontier Foundation, has created a vulnerability equities process where within it actually says that they do encourage the disclosure of the vulnerabilities. But within that process, it's very clear in the redacted document, it is up to the individual agency's discretion. So that's been controversial, that it should be up to the individual agency's discretion. In 2010, the White House cybersecurity coordinator, Michael Daniel, wrote a blog where he said, actually, we should be defaulting to disclosure and only be withholding disclosure when there's a very clear and specific need not to disclose. Fast forward then after the Snowden leaks, and you actually have the Presidential Review Group on surveillance saying that disclosure of these vulnerabilities and working on the process and having a mandatory process is one of the critical things that needs to be worked on within the community. So I think there's a lot of different competing interests here. Where the government's going to net out on those, I think there are conflicts within the administration.
I guess it's also an open question whether the FBI actually knows how they got into the phone.
They might not.
Since it was a third party who did it.
Right, right. I think there are a number of questions about just what's going on here that are relevant to the equities issue that we don't know the answer to. I mean, one of them would be whether the vulnerability that was successfully used in this case is replicated in iOS 9, or if it's something that's indigenous only to, what was it, 7? Was 7 on
7.
Farouk's phone?
Yep.
If it's...
So Farouk's was 9.
Yeah,
it's
it
the
was-
next
it was
one
9.
that'll have the enclave on it, the secure enclave.
So relevant to the next update, let's put it that way. To the extent that it isn't, then the importance of that vulnerability atrophies over time as people trade up their phones or as the bad guys buy the most current thing that's available off the shelf. If it is a vulnerability that is being replicated, then I think the question is going to be really a difficult one for the government, in large part because I think it crystallizes so much the conflict, as David said, that goes on within the government, which is responsible for cybersecurity, believe it or not, as well as for rounding up bad guys and trying to break into devices that the bad guys have used so they can get access to the relevant information and thwart plots and roll up drug gangs and all that sort of thing. I mean, this is crystallized to a T in the very existence of the National Security Agency, which from the very beginning has worn 2 hats. It's head of Cyber Command and responsible for the security of our first military and now increasingly military and civilian networks, at the same time as it's in the business of hacking into everybody's instruments to the extent it can do so, or everybody else's networks, depending on the level at which they're operating. And I have to believe that the reason why this question was left up to the individual agency who owns the device or the mechanism, the technology that can break into somebody else's system and therefore presents a vulnerability, is that there was going to be a holy war if that wasn't the conclusion. That this was simply a power that each of the powerful law enforcement and national security entities refused to delegate to a higher level. And so this was the compromise they reached. That, let's look at the issues, debate them, have an equities process. But at the end of the day, the amount of disagreement, I have no inside information about this. I'm just surmising on the basis of some information about how agencies think about these problems. At the end of the day, it was too heavy a lift for all of the agencies that are in a position to take advantage of these vulnerabilities simply to relinquish the ultimate decision-making power to a higher entity. Now, of course, the president is always the ultimate decision-making power. So when it says that the authority has been left up to the individual agency, you always have to bear in mind that a president can be informed and come to the view that this is definitely something that the United States ought to do. That said, it's a lot more difficult for the president to directly overrule, say, the FBI face-to-face than it is to have a superior organizational structure above the FBI that, in fact, is dictating the decision.
Just everything said makes sense. Just one tiny small addition. I think what David said is exactly right, which is there are all sorts of vulnerabilities, and so the government might find some. Thinking about it from the government standpoint, how confident can they be what percentage of vulnerabilities they've found? So I am thinking about this in an international context. So I found 5 vulnerabilities. I might alert Apple to them, and they fix those 5, blocking me out. Meanwhile, I know my counterparts in Russia and China have quite likely found 5 others each. So they'll now have all this enormous ability to still to enter into the Apple phones, and it will feel like unilateral disarmament for me in an international context. So it's not just, as David points out, between Apple and the U.S. government. It's also the U.S. government thinking about itself with respect to other governments. I don't know if this is still the case, Chris. You can tell me if this is so. It certainly was the case 5 or 6 years ago that if you were a U.S. government official and you were sent to China, you were given a wiped phone and a wiped laptop on your way out the door, and then as soon as you were understood to engage in no sensitive communications when you're in China, and as soon as you came back, it was wiped again, because the assumption was it will have been compromised in so many ways that we will never find out, that we can have no confidence in that device. So because we know that they will have figured out ways to compromise it that we've never thought of.
My understanding is that's still the policy. It's made me even more interested in what former Secretary Clinton was doing with her personal phone when she was over there, because I just don't know the answer to that.
So let's layer one other thing on the vulnerabilities piece, particularly from a public policy perspective. One of the arguments that Apple made that Professor Benjamin and I did not really go into was that they said by the government asking them to develop this code to circumvent the security features, as Professor Schroeder described, that would be, in effect, the creation of a vulnerability, which then there would be much too great a risk of that vulnerability getting out into the wild. So organizations, pick your foreign country, pick your criminal adversary, would be able to get a hold of it. I'll tell you the reason why I didn't make that argument, and I think Professor Benjamin did, and also I find it to be a very strange argument that Apple makes. The way Apple updates code to your phones, for those of you who have Apple phones, is they create code, but then they have to sign the code, and the phone's not going to run any code unless that's been signed from Apple's own signing facility. So what Apple in effect was saying is, even if we create this code, we don't have enough confidence in the security of our signing facility that we think that it would then be signed and loaded onto the phone. Well, if your signing facility gets compromised, that means anybody could run just about any code on your phone and could deliver it likely remotely over the wire, which is a much bigger issue than what we've got here. So from a public policy perspective, how we deal with these vulnerabilities issues and what they mean for people being able to get access remotely to devices is something I think that's going to continue to play out for the next couple of years.
All right, so we've sort of arrived perfectly to our next suit, which is, this panel is entitled Tech Giants versus DOJ, and Microsoft has its own irons in the fire here. It did support Apple breaking with Bill Gates, who actually professed support for the FBI, but Microsoft in 2013, this is less in the news right now, so I'll give a brief synopsis. In 2013, the DOJ served Microsoft with a warrant issued under the Stored Communications Act to produce emails that were stored on servers in a data center in Ireland, which was controlled by a Microsoft subsidiary. This was pursuant to an investigation of international narcotics trafficking, and the emails that were desired were not those of American citizens. Microsoft moved to vacate that order on the grounds that the data was in Ireland and therefore it was extraterritorial and not subject to a US-issued search warrant. And Microsoft wanted DOJ to go through, there's an established sort of, it's called the MLAT process, the Mutual Legal Assistance Treaty process with Ireland, but obviously from the name, it invokes a sense of red tape and time that goes into this. And it went before the Southern District of New York, and Chief Judge Preska basically ruled that the search would actually occur in the United States because with just a click of a mouse, the emails could get back there. And then Microsoft appealed to the Second Circuit. Oral arguments were heard last September by a 3-judge panel of Judges Lynch, Carney, and Bolden. And so this gets right into the international aspect of this issue here. And so my question for the panel is, what do you all think the outcome will be? from the Second Circuit, and what issues do you think it's most likely to turn on there, and would either party be likely to appeal an unfavorable ruling?
So what is really interesting to me about this suit is that it removes from the conversation the image of a cloud. We all talk about cloud computing, but there's no such thing as a cloud. There are third-party servers, and every piece of data that isn't a third-party server has a physical location on a silicon chip somewhere. And so data exists in the world as energy in particular places, and this case removes that analogy of the cloud in an important way, I think. And my own view is that I think Microsoft has got the best of the argument here, to the extent that all its business practices have that information located in a physical place in Ireland, and its business practices don't involve copying that information to other servers that would be within a US territory, which a lot of cloud service providers do. They copy your data in multiple places so that if Ireland collapses, it's still available in Canada, and if Canada, right. So to the extent that it fits with their business practice, they can show up in court and say, honestly, Your Honor, this information is in Ireland. It is never going to transit the United States or come to be in a United States server unless we are vindicating this warrant. And if we vindicate that warrant, then we are on the wrong side, potentially on the wrong side of Irish law. And so all we're asking for is for the Department of Justice to go through the established MLAT program and make sure that we don't get in trouble with Irish authorities. And that's exactly what the MLAT program is there for. And a lot of people are concerned about the cumbersomeness of the MLAT program with different states, and we have to negotiate these treaties bilaterally. There's no universal MLAT. So there's a lot to be said about trying to update the MLAT program, but the fact of the matter is that Microsoft is subject to Irish law if it takes that information out of its physical place in Ireland and brings it over and hands it to the government here. And I think it's in the right to ask that the government use an established procedure for vindicating their legal interest in Ireland before they do it.
Well, I'm not as deeply versed in the laws that are at issue in the Microsoft case as in other areas, but I think what David says is very sensible. It may be legally insufficient in this case to prevent the government from prevailing. There have been cases in which the courts, in response to objections about the extraterritorial location of documents, have said the question is whether you control the documents. And if you control the documents and the warrant is issued in a proper case, please comply with the warrant. There are also some cases in which the private party has quite accurately said, look, we're going to be afoul of domestic law in another country if we comply with this warrant. And to my amazement, at least sometimes the U.S. courts are not very sympathetic to that argument. They want to vindicate the criminal justice interests of the court that has jurisdiction over whatever action is going on. I think the placing of a corporation like Microsoft between a rock and a hard spot with respect to violations of Irish law, if they are put under contempt proceedings to comply with American law, is a very powerful argument, and one with which I have a lot of sympathy. And it may be right as a policy matter that the resolution of this is to stay that process and to let the MLAT procedure grind on. And I use that verb advisedly. It is the farthest thing from a smoothly operating cooperative arrangement with respect to any of the countries with whom we have MLATs. It's where law investigations go to die. I mean, just nothing fruitful has ever come out of an MLAT process, to my knowledge, on a very timely basis. That said, that may be the right result in this case from a policy matter, but there is law on the other side on both of the key questions, I think, which is one, whether if you control the data, please turn it over, and the fact that you may be doing something inconsistent with the foreign country's law is up to you to figure out.
Yeah, I think this is a situation where both the law and the public policy interests here may end up with a situation that's not very good for the users of technology in general. I think this is also true of the Apple case. Apple's done a very good job, I think, marketing that it is important for the user to be able to have the security that the government won't be able to get into the device. Well, taking the flip side from what I argued earlier, we've had 200 years of saying that when an Article III court grants a warrant, that there should be the ability to be able to access that information. By creating a situation where the court cannot get access to that information, what to do if for the technology company to provide that means that they're not going to hold the keys to be able to get access to that encrypted data. What that also means is for an individual user, if you lose your password, you forget your passcode, you're likely not going to be able to get access to your information, wiped clean. So we hear from end users all the time and through our customers saying, that's not a great scenario. Remembering passwords and having to make sure that you don't lose them without being able to back up the data, not productive. Move to the cloud computing environment where it's beyond just the device, but you're actually then taking data and storing it out there, which could be important business data of yours. Not being able to have access to that data in any way, if you lose the password, lose the keys, ends up being a real problem from an end user perspective. The idea that individuals would be able to say that they don't have custody and control merely because the data is held in a different location, that's challenged, I think, by what it means to have custody and control. When you can really just order someone that works for your subsidiary to send you the information. Because of that, you see how Microsoft's adapting to that. They've actually signed an agreement with a German company saying that information in their cloud service, Azure, is going to be stored in Germany, but Microsoft, by contract, says we will not have any access to that data whatsoever. So now even your cloud computing provider won't be able to get you the data if you want, and you're likely not even going to have the ability by contract to demand the entity in Germany to be able to get it to you if you want. Because it's creating a situation that really creates odd obligations on both sides.
I know we're running out of time. Just one very quick note on this. One additional note, others have said. It's interesting to think about how the incentives will go in terms of not only localizing information, as David has highlighted, but also therefore empowering other governments to then have some control over that information. By the way, it might be that the United States' position will more likely lead in that direction. I just want to highlight where that direction goes. So you might have if your image in mind is the German government with enormous concerns about secrecy, then you might hear what David said and think, that's great. The German government will always protect me because they're so worried about it. If instead it so happens that the information is in Russia, you might not feel the same way about Vladimir Putin, and you might feel some hesitation about empowering various governments that we think of as not being sympathetic to privacy, now to be able to make a claim, well, you're in our country, we want to have localized control over you. This is in fact something that happens all the time in the internet context. One of the main arguments against ICANN, a creation of a white paper in the United States, was by other countries was, we want foreign governments to have a seat at the ICANN table. And of course the fear was, right, because you foreign governments you leaders don't like being criticized, and so you'll act in the interest of the leaders, not necessarily in the interest of the citizens. So tiny point to think about here. Localization might be enormously empowering of foreign governments, and with all that entails.
Great. So at this point, I'd like to open it up. We have a couple of minutes left, so are there any questions from the audience? Alex?
I just have a question. We've talked a lot about data at rest, accessing phones and records. I was wondering if there's a difference in the argument if we're dealing with data in motion, like WhatsApp has just made end-to-end encryption part of their platform and other things. I was just wondering if there's any difference in the argument accessing data in that capacity.
Well, with respect to data in motion, that's expressly what CLIA, the Communications Assistance for Law Enforcement Act, was concerned with, and the safe harbor that a provider who has not provided the encryption device does not have to assist the government in decrypting that communication directly applies to those communications. So in my understanding of what WhatsApp has done is done end-to-end encryption without the key. So the decrypting keys are held by, on the one hand, a public key, and on the other hand, a private user who is not WhatsApp. So WhatsApp would not have any obligation to help, and it's not clear that WhatsApp could help if it's a strong enough encryption, which I assume they're using.
The way I tend to describe it is it's a bit like squeezing the balloon, since it's so difficult under the law to get assistance to decrypt that information outside of what's provided in CALIA. Then what the government has said is, well, we're going to look to other entities to get access to that same information. So the information may be transmitted, encrypted while it's being transmitted, but if you can get onto the endpoint device, then at the point where the individual is reading or listening to the information, that's the vulnerability. I think that's actually why you see so much interest in some of these issues stored on the endpoint devices.
One last note on that. If you're traveling internationally, back to this localization point, we're taking it really seriously. I guess you'll have bits of data streamed throughout the countries of the world. So there'll be little bits of you in as many countries as you travel to.
Digital exhaust is
Yes.
yeah.
Exactly.
Yes. Regarding the argument about whether computer code is speech, would it work to categorize writing code as speech, but like doing things with code as doing things that aren't speech, and therefore kind of limit the argument that way? Or is there a reason that wouldn't work?
Sure. No, I mean this is. I think this is a legitimately tough question. So imagine that you are. I mean, the classic example really is the case involving the overcoming of the DCSS, the encryption for music, etc., where I say I want to tell the world this is how you overcome encryption, and the most effective way for me, better than me writing an essay that says. Here's how you do it. I'm actually just going to walk you through step by step so you can understand how it is you would do it if you want. That really does seem like I'm having a communication to you. I'm writing words, you can understand them, etc. And so one easy way, again, this is sort of, you think about source and machine code, right? Drawing that distinction. There are other lines that can be drawn as well, because some people don't buy that distinction between source and machine code and want to go in other directions. The only point that I was trying to make is, I do think at the end of the day, the First Amendment is focused on, the speech is about some substantive communication that I can have with you, where I can actually send a message that you can receive and make some sense of. That's my point. If I just start making dolphin noises, and I say, oh, in those dolphin noises, I'm communicating to you, this will be over in 5 minutes. No, you say, I have no idea what you've communicated. All I heard was dolphin noises. So for lots of purposes, that's how machine code will be. And if it's just at that computer to computer level, it's harder for me to see there's a substantive communication there.
All right, so I think that actually brings us to the end of our time today. Our hope with this was that you would be able to go out into the world as more educated consumers of the news articles on this subject, and so I hope we've achieved that. Please join me in giving a hand to our panelists today.